This needs to be 750. Well, the U.S. Supreme Court is back in the headlines. And this time, it's not because of a big decision, but because of something that Justice Ketanji Brown Jackson said from the bench that's got a whole lot of people talking. During oral arguments this week, it was in the Louisiana voting rights case, Louisiana versus Callis. Justice Jackson invoked the Americans with Disabilities Act. The Americans with Disabilities Act to make a point about race based redistricting. People were scratching their head. Americans with Disability Act to, to make a point about race based redistricting. Are you kidding me? And let me tell you, it didn't go over too well. Now, before we get into what she actually said, here's the backdrop. This case is about how far states have to go to consider race when they draw congressional maps under Section 2 of the Voting Rights Act. Louisiana Republicans argue that their map, which includes only one majority black district out of six, very similar to my home state of South Carolina, we have one out of seven. They argue that this was drawn fairly and without discriminatory intent. Civil rights groups claim it still needs results in black voters being underrepresented, even if no one intended to discriminate. Now, that's the big legal debate here, intent versus outcome. So during questioning, Justice Jackson, one of the court's most liberal members, jumped in and said basically, hey, discrimination doesn't always depend on intent. Sometimes systems themselves are unfair by design. And that's when she used the ADA as an example. She said, Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. She compared that situation with how the voters' right intended. Let me just let you listen to her yourself. And with that, as you can imagine, the internet exploded. Critics jumped on the comment, accusing Justice Jackson of comparing black voters to disabled people, which she kind of did, didn't she? Now, I guess to be fair, she was trying to use an analogy comparing access to buildings under the ADA to access the ballot box under the Voting Rights Act. It's not exactly how it came across, though. In today's world, words matter. They remind us of that. And when a sitting Supreme Court justice uses the phrase, they're disabled to describe minority voters, that's going to kind of raise eyebrows. That's kind of a big deal. So let's be honest here. The optics here are terrible. You have the first black woman ever appointed to the Supreme Court, essentially suggesting that black voters need the government to build a ramp so they can participate equally in democracy. That's not just a poor analogy. That's patronizing. I mean, it reinforces this tired progressive narrative that minority Americans are somehow helpless without government intervention. That's insulting. That's not empowering. Now, the justice was following up on a line of questioning from Justice Elena Kagan, who was pressing Louisiana's lawyer on whether states must remedy discrimination, even if they didn't mean to discriminate. But what Miss Jackson was arguing, and this is the key, is that intent doesn't matter if the outcome produces inequality. That's the philosophical divide here. Conservatives believe the Constitution guarantees equal opportunity, that the law should be colorblind. Liberals, on the other hand, often argue for equal outcomes, meaning if the results aren't balanced, government has to step in and fix it. Government's always the answer, even if that means using race as a factor. That's what this Louisiana case is really all about. So when Jackson made her ADA analogy, the Louisiana Attorney General respectfully pushed back, as should have. He said, "The difference, Your Honor, is that remedies under the ADA aren't race based." And to her credit, Jackson immediately agreed, saying, "I take your point." But then she added, "So what you're saying then is that if the problem of no access is about race, it's just too bad because you can't have a remedy that relates to race." The attorney said, "Absolutely not, Your Honor." But at that point, the damage was done. Her use of the word disabled in context with race was already out there. It was already making waves online. People were already responding on X within hours. Critics on X we're calling it a Freudian slip that revealed how the left views racial politics. And they're right. Some wrote, "Did she just call black voters disabled?" Others said it showed how liberal elites see minorities not as equals, but as dependents, forever needing protection, forever needing oversight, special accommodations in every situation. And honestly, they make a fair point, don't they? Think about it. Justice Jackson's argument might have sounded academic in the courtroom, but the underlying message fits perfectly with what we've seen from the left for years. This idea that America is inherently unfair, that minorities are victims who can't succeed without government assistance. That's the same thinking behind affirmative action. It's the same thinking behind DEI programs. It's the same thinking behind race based hiring and college admissions quotas. And it's exact mindset that many Americans, especially minorities themselves, are rejecting. They don't want any part of it going further. Now, here's what's interesting. Justice Jackson defended her comments by referencing a previous Supreme Court case, Allen versus Milligan from 2021, where the court also used the term disabled metaphorically to describe unequal access in voting systems. So she didn't just make it up out of nowhere, but context does matter. That case wasn't about analogies. It was about how maps in Alabama limited minority representation. And in that opinion, disabled was used to describe the process, not the people that they were talking about. Jackson blurred the line, and that is what's drawing the heat.